Welcome to Getting Facts into a Remote Proceeding Tax Court Case, sponsored by the ABA section of Taxation. If you are seeking CLE credit, you must attend the entire program. Partial credit is not available. Please do click on all participation verification alerts during the program to confirm your attendance. Immediately after the program ends, a link to complete the certification process will appear. Please complete the evaluation and the CLE affidavit, providing your bar information as requested. Once the completed form is submitted and your attendance verified, your certificate will be emailed to you. I would like now to turn the program over to today's moderator, Professor George Willis. Professor?
Thank you, Chris. Well, again, welcome to our talk today, Getting Facts into a Remote Proceeding Tax Court Case. This is the final webinar in a three-part series entitled Just the Facts. This was offered free in lieu of the canceled 2020 Low-Income Taxpayer Representation Workshop. As already mentioned, if you missed the other webinars in the series, they're available on demand on the ABA's website. For information, the other panels were Getting Facts from Third Parties, FOIA, and Other Avenues. And the second panel was Getting Facts in the Administrative Record in CDP or Collection Due Process cases. I would first like to briefly introduce our panelists for today. First off, we are pleased to have Special Trial Judge Diana Layden, who will give us perspectives from the tax court. Judge Layden has, sort of done it all. After clerking at the tax court, she spent time in private practice at several law firms before she went to the government side, working at the Departments of Revenue in both Massachusetts and Connecticut. She also had a long tenure as an academician, directing the tax law clinic at the University of Connecticut, after which she was appointed to the then newly formed position of taxpayer advocate for New York City. Finally, in 2016, Diana was appointed to the U.S. Tax Court. Judge Layden has been an active member of the ABA tax section for as long as I've known her. She's a former chair of the section of low-income taxpayer, or the Low-Income Taxpayer Committee, and was a recipient of the Janet Sprague's Pro Bono Award in 2005. So, Judge Layden, thank you very much for joining us. To give us perspectives from respondents' viewpoint, I'm pleased to introduce Rachel Rawlins. Rachel is a senior attorney at the IRS Office of Chief Counsel in Washington, D.C. She earned her Juris Doctor from the University of Virginia School of Law and has over a decade of experience at the Small Business Self-Employed Division in Washington. Welcome, Rachel, and also thank you for being with us. And last but not least, finally, Jamie Steele is an associate with Morgan, Lewis, and Bacchus in their Washington, D.C. office. Jamie's primary concentration is federal tax controversy work. After receiving his LLM in taxation from NYU, Jamie served as a law clerk to Judge Kiecki of the United States Tax Court and joined Morgan and Lewis thereafter. So, Jamie, also thank you for joining us. Okay, as a sort of 35,000-foot overview of where we're going today, we will cover the things that you see on this slide. However, we're going to especially highlight procedures that may have changed in remote U.S. tax court proceedings when it comes to obtaining facts and evidence. We'll first look at how you get facts into evidence in situations that either the petitioner or the respondent is already in possession of. Then we'll discuss situations where you are trying to obtain evidence or facts from an outside source. Maybe you need a bank record. Maybe you need an employer's policy on something. Stipulations will be weaved into a lot of the discussion today. We assume that you, the listener or the viewer, has some basic knowledge of the tax court stipulation process. So we're not going to dive too deep into the weeds on that. However, this is where you will start to see some differences under the court's COVID guidance from what you may be used to. Then we will wrap up with a whole host of pretrial issues. And you'll really see how important deadlines have changed under the remote proceeding guidance. Before we get into all that, though, we'd like to do a quick poll or survey of the audience. We have two questions, and this will only take a second. My first question to the audience is, have you ever filed a stipulation of facts with the U.S. Tax Court? You can chime in online now. Again, the question is, have you ever filed a stipulation of facts with the U.S. Tax Court? Okay, the answers seem to be slowing down. It is about 55, 56% yes, and about 45, 46% no. So a little bit more than 50%. Okay, my second question. Are you aware or are you familiar with the U.S. Tax Court's changes to the standing pretrial order regarding stipulations of facts under these new guidelines for remote proceedings? Again, are you familiar with these new standing pretrial orders since COVID? Okay, so the answers are slowing down here, but this is a little bit more lopsided. I see that about 23% are aware and a good 75, 76% are not. So I think this will be a very useful CLE for those of you who are not aware of this or who have not done a STIP yet. Okay. Let me get back to the slides. Okay. I have hyperlinked the major COVID-19 resources available on the tax court's website. We will talk about most of these in turn, so I'm not going to go into them in detail here, but these PDFs, along with PDFs of the various tax court rules that we will cover, and also, very importantly, the IRS's Memorandum of Understanding regarding the use of email are all included in the meeting materials for this presentation. I'd like to now turn it over to Jamie Steele to kick off part one of our discussion, and this is negotiating facts that the parties already have. Jamie?
Okay, great. Thanks, George. And I think the polls were helpful in letting us know who the audience is. And it looked like it was about half and half that filed stipulations. So I think some of this background that I'm going to provide on just the general discovery process for parties will be helpful. And I think we can all agree that discovery is a big part of getting a case ready for trial. And I don't think that's changed much as a result of the COVID pandemic. And unlike tax court trials, the COVID pandemic has had less impact on this aspect of practice, at least for my practice, which I'm in private practice, and I think maybe with Pro Se or low-income clinics, it's maybe a little bit different view. But parties still need to obtain information from one another, and that can still be done by all the traditional means, by mail, by email, or other electronic methods, just like before. In certain instances, there were situations pre-COVID where it was easier for a taxpayer to just drop materials off with the IRS. And I think that's an issue that disproportionately impacts, but it's not necessarily limited to pro se petitioners. I think there are probably fewer instances where that can happen now, unfortunately. So while discovery in my world hasn't changed that much, I know it has for a lot of other taxpayers. And Rachel, George, have y'all noticed any big differences in discovery?
I mean, yeah, from the perspective of a chief counsel attorney, I do think discovery has changed quite a bit, both as far as obviously the new rules and procedures that the court has implemented, and like you mentioned, Jamie, just the practical effects of operating almost completely remotely. I know, at least for my office in Washington, D.C., we're all pretty much home full time. And like you said, I mean, we're not interacting with taxpayers in person at all as far as dropping off documents. Even mail can be challenging as far as getting actually delivered to the office and then eventually, accessed by whichever attorney is assigned to the case can take quite a while. So it just delays everything. I think it's really just forced us to work as a lot further ahead as far as the timeline. We've really tried to push everything back and start everything a lot earlier whenever we can, because things just take a lot longer. But overall, I think it's been really impressive how quickly the court and the taxpayers and their representatives and the chief counsel attorneys have all been able to sort of adapt to this, this new world we're living in, and try to make sure the cases are continuing to move forward in a timely manner.
Okay, great. Thanks for sharing your views. So those points aside, we wanted to get started today by providing an overview of the discovery process, both informal and formal, in the tax court. At a high level, fact-finding with respect to a party in tax court cases come in two forms, informal and formal discovery. Fact-finding is necessary in almost all cases. That's even where the issue is purely legal. The parties need to at least be able to agree to the facts necessary to allow the court to reach the legal issue. I'm going to talk about informal discovery first because, necessarily that happens first in practice, and this process is sometimes referred to as the Brannerton process. I'll call it that throughout the presentation today. And informal discovery is a critical part of a tax court case, not necessarily unique to tax court, but is very different in the tax court from other federal courts. And not only is it critical, but it's mandatory under the tax court's rules. Rule 70A provides, however, the court expects the parties to attempt to attain the objectives of discovery through informal consultation or communication before utilizing the discovery procedures provided in these rules. Rule 90A, which deals with requests for admissions, has similar language. And at the end of the day, before implementing the formal discovery process, the tax court rules require parties to pursue the objectives of discovery through informal discussions and consultation. The informal discovery process applies to all of the formal discovery requests, specifically to interrogatory requests. Those are in Rule 71, production of documents, Rule 72, and depositions, Rule 74. Also, the same limitations on discovery apply. I'll talk a little bit more about those later, but for example, they can't be unreasonably cumulative or duplicative. They can't be overly burdensome. Those rules are found in Rule 70C. So the Brannerton process generally begins with one party sending a so-called Brannerton letter to the other party. I've seen instances where petitioner sends the first letter. Other instances, the respondent sends the first letter. It seems to be a case-by-case situation. I'm not sure there's really any rhyme or reason. It's just, which party gets around to it first from my perspective. The next step is the Brannerton conference. Sometimes the Brannerton letters don't precede it. I've seen it go both ways as well. But the Brannerton conference should take place so that the parties can discuss the informal discovery requests. I've always found the Brannerton conference to be a useful check-in. It's often the first time that petitioner and respondent get to discuss the case. I found that it can be more useful if the Brannerton letters have been issued. Sometimes documents have already been provided at that point. Sometimes they haven't. But, I do think that whether the Brannerton letters have already been issued and documents exist or have been produced can really have an impact on the utility of that conference. The conference can take place by phone, can also take place in person. These days, it's not very likely to be in person, just for obvious reasons. The pandemic has changed a lot of things. And I'm actually not even sure if it would be possible if IRS employees are able to meet in person. Rachel, do you know if they are?
That's actually a great question. I'm not sure if we're like prohibited, but I do not know of anyone who has. So I think people are generally just avoiding it for everyone's comfort level for now. But I'm not sure you have like an actual prohibition on it.
Okay, yeah, that makes sense to me.
I can vouch for at least Southern California. The answer is no, they are not meeting in person. One thing while we're here, and I'm sorry to interrupt, but with COVID delays and mailing, it's really, you had mentioned, Jamie, that sometimes you'll get the call before the letter, or the letter far, far, far before you're ever going to get a call. And with COVID, it's really, turned this upside down. So I have found that we are getting more calls for Brannerton, or calls way ahead of the letter these days.
Okay, that's helpful to know as well. So turning to informal discovery requests, the Brannerton informal discovery process is more than just a suggestion from the court. The rules make it clear that it's required. The court expects the parties to make an earnest attempt to work with one another prior to turning to formal discovery. There are a lot of cases out there that have language similar to the bullets that I've set out in this slide. For example, the rule contemplates consultation or communication, words that connote discussion, deliberation, and an interchange of ideas, thoughts, and opinions between the parties. Clearly, a back and forth process is expected. A principal purpose of the requirement for informal discovery is to save the time and resources of the court and of the parties before it in the development of relevant and undisputed facts. Those excerpts from the court aren't unique. The party should seek information from the opposing party, give a reasonable opportunity for the opposing party to respond, and then only after those efforts fail should the party turn to formal discovery. The tax court carries a huge caseload, and the informal discovery procedures as well as the stipulation process are intended to allow the parties to work through fact-finding process with as little judicial involvement as possible. I think it expedites the process for the parties as well as for the court, and everyone can be thankful for that. And generally, the court will not enforce a formal discovery request if the party seeking enforcement has not first sought to obtain the information informally. That's kind of the stick. If you don't first go through the informal process, then a motion to compel is going to be unsuccessful if you've not, done what you were supposed to first. So if you didn't use the informal process to begin with, the court likely will direct the parties to seek to informally resolve the discovery issue first before perhaps granting a motion to compel under Rule 104. If the parties go back and are still unable to resolve the discovery dispute informally, then the court might compel production if there's a formal discovery request in place. The Brannerton process and the stipulation process are intertwined. We debated whether to talk about the stipulation process in this part of the presentation, but it's really hard to separate them. They are so intertwined. And the court requires parties to engage in the informal discovery process, and it also requires the parties to stipulate to facts to the greatest extent possible. Without the underlying information that's obtained throughout the discovery process, the meaningful stipulations wouldn't be able to really take place. And the court itself has called the stipulation process the bedrock of tax court practice. That was in Brannerton, which also really made clear how important the informal discovery process is.
Jamie, can I make a comment right here? So,
sure.
For those who, and this kind of relates back to Brannerton and the phone call, a lot of, at least in my world, the low-income taxpayer world, a lot of pro se petitioners think whatever they have sent into the IRS as a part of exams or maybe appeals is in the administrative file that's with the area council. And so it's constantly, I've already sent that in. And that is, and I just want to say there's a lot of frustration with that they don't understand that this is separate from what you have done previously.
Okay. Yeah, thanks for that, George. So it's turning next to Rule 91, which is the rule that provides for stipulations for trial. It provides that the parties are required to stipulate to the fullest extent to which complete or qualified agreement can or fairly should be reached. All matters not privileged which are relevant to the pending case, regardless of whether such matters involve fact or opinion or the application of law to fact. The court expects the parties to stipulate to as many facts and documents as possible. It helps expedite the process. It gets relevant facts before the court for trial. One other noteworthy point from the rule is that burden of proof is irrelevant in the stipulation process. The court also expects stipulations to be comprehensive. The fact that any matter may have been obtained through discovery or request for admission or through any other authorized procedure is not grounds for omitting such matter from the stipulation. Those procedures are regarded as aids to stipulation, which makes sense. You go through the discovery process, you produce documents to the opposing party, and then, once you have all of the relevant documents and facts in front of you, you can stipulate to them. In terms of filing the stipulations, they should be filed by the parties at or before commencement of the trial of the case, unless the court in the particular case shall otherwise specify. As Rachel will talk about a little bit later, that's one of the procedures that has changed as a result of the virtual trial setting. One other important thing to note is that a stipulation, when filed, need not be offered formally to be considered in evidence, and that's distinguishable from the discovery responses and requests. So it's very important for the stipulations themselves. For objections, any objection to all or any part of a stipulation should be noted in the stipulation. But the court will consider any objection to a stipulated matter made at the commencement of the trial or for good cause shown made during the trial. And then in terms of the stipulations themselves, they do have a binding effect. The stipulation shall be treated to the extent of its terms as a conclusive admission by the parties to the stipulation, unless otherwise permitted by the court or agreed upon by the parties, and that's on a where justice requires standard. And so what all of that means is that facts developed during the informal discovery process are critical. Parties are required to stipulate to the fullest extent possible. They have to stipulate to all matters that are not privileged. Evidentiary privileges and 6103 would be included there. Parties have to stipulate to what is relevant to the case and stipulate to matters that involve either fact or opinion or the application of law to fact. Worth noting, the court is not bound to accept a stipulation as to questions of law. And under COVID, it also means that the Brannerton conference may be by telephone or Zoom. I mean, a lot of times that happened before, but it's obviously more likely to happen by telephone or Zoom these days. You may be getting more documents by e-fax or email. The IRS may require a memorandum of understanding agreement to use encrypted email attachments. I'll let Rachel explain a little bit more about that procedure. Rachel, if you don't mind.
Oh, yeah, absolutely. So the IRS Office of Chief Counsel has pretty strict rules about what information can be shared via email, and these have been in place for forever. And the rules are in place to protect the taxpayer's personally identifiable information and return information, and that's because the IRS doesn't want to worry. We can't guarantee that our email is secure. And this is often inconvenient, even in a world where we could have in-person meetings. But it's obviously a lot worse these days. So things have changed a lot. And as soon as COVID hit, I think the Office of Chief Counsel really did try to quickly adapt in providing a few new ways for Chief Counsel employees to be able to transmit emails that contain return information or other personally identifiable information, both to taxpayers and their representatives. So before COVID, there was a basic procedure in place for the parties to sign what we call a Memorandum of Understanding, or an MOU, which would then allow the parties to send secured emails to each other. This only worked with very specific software and encryption methods, so it was actually very infrequently used. But in June of 2020, there was a new Chief Counsel notice that was published that added 2 new encryption options, which are much easier and easier to figure out for sort of the general public. We can now use either Adobe Acrobat Pro password encryption, where we can send encrypted PDF attachments to our emails, or Microsoft Office 365 Protect documents, which will encrypt and send attachments that are from in different Microsoft Office formats. So to be able to use these new methods, basically we just have the taxpayer review and sign a prepared Memorandum of Understanding, which the taxpayer basically will agree to use the specified email encryption method, and they have to acknowledge that there's risks of using email to send personally identifiable information. But this has generally been working out pretty well and helpful in practice these days, so we don't have to physically go to the office to get all the paper documents, and we can pretty quickly transmit documents back and forth.
While we're here, 2 things. One, I think it's great that on the Memorandum of Understanding, and there's audience, there's a template in the materials we've provided. You can add people. This does not just mean the petitioner. So we've had situations where there's language barriers or technology barriers where, for example, the daughter has been authorized to receive information on behalf of parents. And so you'll see that, I think it's on page 3 of the MOU that we've provided. Okay, that's all I have. Thanks.
Okay, thank
you.
Wait,
I'm sorry. I'm sorry to interrupt again. We did have a question in the chat box, and I think it's appropriate to take it here instead of the end because we're not going to be talking about MOUs beyond this. There was a question about uploading signed MOUs to Dawson blank without the area council's or respondent's counsel's name on it. This is not a tax court document. This is a document between the IRS and petitioner. So I don't think that would work. Back to Jamie.
Okay, yeah. I think that's probably right, George. When I've encountered the memorandums of understanding, it's been generally during audits. I haven't had them much lately, but I understand that they are now being used with IRS counsel during the, discovery process to help facilitate getting information back and forth between counsel or perhaps the parties, which, moves on to the next bullet point here, which is other methods of delivery. So we mentioned fax and email as well as just regular mail, but for some larger documents, that's not always possible to use. Email has a size restriction a lot of times, so flash drives, secure drives are things that might work, as well as certain. I've tried a secure file transfer. I know that the IRS can be resistant to that. I'm not sure if it's because of their IT or what the cause for that is. Rachel, do you know?
Yeah, I mean, our computers are so limited. We don't have. I don't think we can accept. I don't think any of these, as far as Dropbox, OneDrive, Google Docs, none of those work on our work computers. We can use like flash drives, so that's definitely still an option. Even CDs are challenging. we have external CD drives in the office, but our laptops don't even have CD drives, so that's not really helpful in these days. For very large cases, we have large litigation technology software that we can use with our very large cases. But for the typical sort of day-to-day cases, I'd say ultimately email, fax, and flash drives are probably the easiest way to transmit documents these days for the Office of Chief Counsel generally.
Okay, thanks. That's helpful. So just one final point on this slide, and that's special issues with pro se petitioners. I know that I've heard a lot of pro se petitioners don't necessarily sign up for e-access, which can cause problems. We were talking about delayed mail that can impact those taxpayers, as well as just general lack of computer access for a lot of pro se petitioners. Maybe some don't have great computer skills either, reliable access to internet. Sometimes the cell phone is the computer. And, sometimes a cell phone that a pro se petitioner might have doesn't even have access to the internet. And all of these can be hurdles to allow the pro se petitioners to communicate with IRS counsel, transfer documents, and sometimes even interface with the court. So turning to formal discovery, I'll just try to give a high level of some of the rules, the relevant rules on formal discovery. But as discussed, after working through informal consultation or communication, the parties then can move on to the formal discovery process. And I've always viewed formal discovery as formalizing prior Brannerton requests. So you issue an informal request. If you don't get a satisfactory response, then you formalize that request. And then if you still don't get that, the response you're looking for, then you can take further action. There are various types of formal discovery, but all are subject to that informal discovery process. Just a few general rules that apply to formal discovery. These are all located in Rule 70, but the scope of discovery, the information or response sought through discovery may concern any matter not privileged and which is relevant to the subject matter involved in the pending case. There are a few other limitations on discovery. For example, the discovery sought is unreasonably cumulative or duplicative, or is obtainable from some other source that is more convenient, less burdensome, or less expensive. There are quite a few others that are listed under 70C that I won't get into. And then another point that I mentioned before is just the use in case. It's important to keep in mind that such answers or information or responses will not be considered as evidence in the case until offered and received as evidence. So to be contrasted with the stipulations, which don't have to be separately entered in to evidence. So Rule 72, it provides what I see most often, which is just the rules about document requests, seeking the production of documents. Any party without leave of court can serve a document request on another party. There's a 30-day response time associated with these. The court may allow a shorter or longer time. A party can make objections if it deems those objections necessary. Those would be based on sort of the scope as well as the other limitations points that I was just talking about. And if an objection is made to only a part of an item or category, then that part shall be specified. To obtain a ruling on an objection by the responding party, the requesting party shall file an appropriate motion with the court. But one thing to note is that, prior to filing a motion with the court, the request nor the response would be actually filed with the court. So that's something that would be attached to whatever motion was filed with the court. There are similar rules that apply to interrogatories. A party can issue or serve upon any other party no more than 25 written interrogatories, including all discrete subparts. There's a special rule that excludes the interrogatories relating to the identification of expert witnesses. There's a procedure for answering. You have to state any objection. The responses have to be within 30 days. A motion would be the way to deal with non-responsiveness, and that would be filed by the party who issued the interrogatories. And just like with the document request, the request nor the answers or responses would be filed with the court prior to the filing of a motion. There are also some rules about depositions. Those aren't nearly as common and, in fact, are deemed an extraordinary measure in tax court practice, but there are special rules for party and non-party witnesses, as well as depositions that receive consent from the counterparty or non-consensual depositions. There are also rules surrounding requests for admissions. I guess before I turn to that, I'll just mention two other points that relate to the general discovery rules. Rule 104 provides enforcement action. That's the rule that provides guidance on how to file a motion to compel, where the moving party asks the court to compel the opposing or non-responsive party to respond to the outstanding formal discovery requests. And there's also a protective order, which is a toolbox for the recipient of whatever discovery request, that if they feel like that request would lead to annoyance, embarrassment, oppression, or undue burden or expense, they can file a motion for protective order. A successful motion for protective order might result in the moving party not having to respond to an unreasonable discovery request. Request for admissions, a party may serve upon any other party a written request for the admission for purposes of the pending action only of the truth of any matters which are not privileged and are relevant. Responses have to be made within 30 days, which is the recurring theme. And the effect of any admission is that any matter admitted is conclusively established unless the court on motion permits withdrawal or modification of the admission. So effectively, it's just another method for collecting information that the tax court rules allow. And then turning finally to what happens if the parties are unable to reach agreement with stipulation. So we've talked about the discovery process and how that moves everything along towards the actual ability to make a stipulation, but parties aren't always going to agree that certain things should be stipulated to. And if that occurs, one party may end up filing a motion to compel a stipulation where they would ask the court to require the other party to either engage in discussion or provide a reason why they're unwilling to agree to a stipulation. If no response, so I guess if that motion is filed, then there would be 20 days to respond, and then if no response is received with respect to any matter or portion thereof, the response is evasive or not fairly directed to the proposed stipulation, that matter or portion thereof will be deemed stipulated. And, one thing I've always wondered is how to reconcile that, if parties can't agree to a stipulation, does the court prefer the parties to, run and seek help to try to force the other person to stipulate to a particular fact, or whether the parties should just not stipulate to that fact? And Judge Layden, do you have a view on that?
Well, two views, and these are my personal views. I can't talk for all the other judges on the court, but usually if the parties are working at a stipulation and they come to loggerheads on a particular stipulation, I don't really get involved. If at trial they need to introduce testimony or they have an exhibit they couldn't stipulate to, then I would take it up. But the other thing I have seen, and again, we're seeing this, I'm seeing it more frequently at the court in the era of COVID, people are moving. And so many taxpayers, many petitioners do not sign up for e-access. So the only way they get information is through the U.S. mail. And that's been delayed. And so many times no responses to a Rule 91F motion to compel stipulation goes unanswered. My approach is if I go to trial and that person either shows up at the calendar call or has counsel at that time, I will entertain a motion to vacate the order granting the motion to compel. But I've got to have some kind of discussion. But we are finding, I think, as in pockets throughout the U.S., people just are not responding because they've moved, or God forbid they've died, or they have, family members who are critically ill. So my pitch to everybody out there is, if you help pro bono clients pro bono, please, even if it's just to advise them, have them sign up for e-access. We are now, you're able to get our case management system on a smartphone. Many petitioners who have signed up do that. So that's my 5-minute pitch.
Okay, thanks, Judge Layden. So with that being said, I'll turn it over to Rachel to discuss non-party discovery.
Great, thanks, Jamie. So yeah, we're just going to switch gears a little bit. We're talking first very briefly about informal discovery involving people who are not parties to the litigation. Most of the tax court rules and the interpretative case law that has come out on these rules about discovering information by informal means generally do not apply to discovery of third-party testimony and documents. There's an exception for non-consensual depositions of third-party witnesses. But overall, the Chief Counsel's policy is that the field attorney should contact any third party that has potentially relevant information informally first. And that can be with or without the petitioner's cooperation. And they should do that before moving on to using things like depositions or subpoenas. This is, again, just in the spirit of Brannerton. We believe things will ultimately go more smoothly if everyone is working together voluntarily. Some third parties are happy to cooperate voluntarily, whereas others may have, possess information that may be privileged or that they cannot voluntarily disclose without the issuance of a subpoena. So it really just depends on the specific third party and the information that's being sought. Typically, we're looking at just beginning with an informal telephone conference to try to gauge the witness's level of cooperation and knowledge. A quick note on Section 7602C, which generally covers notification of the taxpayer of third-party contacts. This requirement does not apply with respect to matters that are in litigation. So typically, a chief counsel attorney would not have to inform the petitioner in advance before contacting a third party. But sometimes at least personally, I find that it's great to include the petitioner if they're willing. If a third party knows that the petitioner is aware of what's going on, that the petitioner wants the information to be shared to potentially move the case forward or resolve a specific issue, generally a third party is much more willing to talk if everyone's on the phone together. So I certainly don't avoid including a petitioner if the petitioner is willing to cooperate in that sort of process. If we ultimately do determine that a third party has potentially relevant information and that they might be needed at trial, we will typically issue a subpoena, even if we believe they will be cooperative. Fortunately, even the most seemingly cooperative witnesses can change their minds when it comes to actually appearing at a trial. So moving to formal discovery for relating to non-parties. You'll see here, this is Tax Court Rule 147. This covers tax court subpoenas, which can generally they can be issued by either party on a form that can be actually just printed from the tax court's website directly. The subpoena can direct a person to attend and give testimony at a time and place listed, or can command a person to produce books, papers, documents, electronically stored information, or other tangible things. Subpoenas cannot be issued until the case is set for trial. where this slide sort of starts to address these COVID-19 specific changes to the rules and procedures. Whereas subpoena is for a witness to appear at a trial, the party serving the subpoena has to list the trial session Zoom Gov information as the location so they can appear remotely. And that's really the only big change in the procedure for subpoenas issued just for witness testimony. There are a lot more, there's a lot more changes in the subpoenas for production of documents. So here's some of the highlights. At least 45 days before the trial session, a party can move for a document subpoena hearing. So basically you have to file a motion. You can lay out sort of the issue in the case to which the subpoena will pertain and explain why the subpoena is necessary. The court may conduct a conference call or video call with the litigants, and if the court ultimately grants the motion for the document subpoena hearing, the judge will issue an order setting the case for a remote hearing and issue a notice of remote proceeding. The hearing date will generally be about 2 weeks before the first day of the trial session. And so once this is issued, the party can prepare a subpoena package with the hearing date and the Zoom Gov information for the hearing.
Rachel, if you don't mind, this is so late, and I'm going to interrupt here for a second to give some more information. So the rules for the court for subpoenas for documents is quite unique. And the court has for many, many years sought changes legislatively. The problem was that the subpoena had to be returnable at a session, at a trial session. Well, that of course didn't work in the time of COVID. So what the court has done, and it seems to be working actually quite well, is every week on a Wednesday, there is tentatively scheduled a hearing for these motions. And right now, the special trial judges rotate, and we cover those hearings. I have not seen a lot of use by practitioners or pro bono attorneys on this, which surprises me, because when I was a clinician, we had a terrible time getting documents from financial institutions. But if we issued a subpoena to the financial institution, suddenly they were very cooperative. So, again, and then of course, if you get to the hearing and somebody moves to quash or there's another challenge to it, it may be likely that the special trial judge who is holding the hearing may kick the case back to the judge who is assigned to the case. So you may not have a resolution there. I think that's one of the reasons why, the special trial judges who are having these hearings are making use of conference calls and trying to figure out if there's any challenges ahead of the hearing date.
Great, thank you so much for adding that. I don't know. I mean, I know at least a handful of attorneys in my office have gone through this procedure and have found it to be working pretty well. Let me move on to the next slide. So the court has sometimes asked the parties in their orders granting the motions for document subpoena hearing to notify the court a few days before the document subpoena hearing to let them know whether there has been compliance with the subpoena and whether the hearing is no longer necessary. So because of this, if time allows, we're typically trying to ask the third parties to provide the documents in advance of the date set for the special hearing. We obviously can't compel the third party to do so, but if they do provide the documents in advance, we can then inform the court that no hearing would be necessary. The Office of Chief Counsel procedures again, to sort of fit in with these rules, typically if we get close to the date of the document subpoena hearing and we have not heard anything yet from the third party, we do try to send a follow-up last chance letter to the subpoena recipient about 10 days prior to the hearing if we haven't received the requested documents. But if they still fail to respond to that letter and they fail to appear at the document subpoena hearing, a party can file a motion to enforce the subpoena and seek appropriate sanctions against the subpoena recipient. Similarly, if the documents are absolutely necessary for a party to have before the trial, the party can consider requesting a continuance to be able to have the time to obtain the documents. So this slide just has the complete guidance. And again, there's a lot of changes in the procedures. It seems from, at least in my office, to be working pretty well so far. I'm not sure what the experience has been like around the rest of the country, but in the DC area, it seems to be working fine. I'm going to turn briefly now to depositions. I'm not going to go into too much detail on this because there's a lot, even pre-COVID. There are different types of depositions. There's numerous tax court rules that cover this in quite a bit of detail, and that gets very complicated. So I don't want to cover it, get into it too much. It is a less frequently used tool for a number of reasons. Typically because it's considered generally an extraordinary method of discovery. It also can be quite expensive because the parties will have to have a court reporter present. So, typically it's a tool that's used in larger cases or very specific circumstances where a deponent, for example, may not be available later for trial. I'm just trying to, they are obviously very useful tools. From the Office of Chief Counsel's perspective, I think, the taxpayer is the person that's most likely to know the facts of a case and to have the easiest access to the facts from either themselves or from their employees or advisors. And it's, the whole purpose of discovery is to, try to obtain these facts in advance and avoid them just coming out the day of trial and not, being surprised by something in the day of trial. So we try to use all the informal discovery and other formal discovery tools before we would ever use a deposition. But depositions can certainly be very useful to clarify the facts of a situation or to have the taxpayer sort of commit to a position in advance of trial. So certainly they are used, but just not as frequently. Remote proceedings have not changed the official tax court rules as far as depositions and timing go, but practically, obviously, there have been many changes because in the past, depositions were almost always conducted in person with the parties and the deponent all in the same room with the court reporter, which is not currently possible. Tax Court Rule 81J, however, does provide that depositions may be video recorded. Historically, this was done by like a videographer, but that was often prohibitively expensive. So with Zoom now, Office of Chief Counsel has a way to record a deposition at no additional cost to the government. So I know the Office of Chief Counsel has been using ZoomGov now to video record depositions in docketed tax court cases. My understanding is that they basically use a paralegal that acts as a camera operator for purposes of Tax Court Rule 81J. And so yeah, everyone else was in separate places and, including the court reporter, but ultimately a video recorded deposition is permitted and can be used at trial or at a hearing in the same manner as a written transcription. So that was sort of already built into the tax court rules, and so that really hasn't had to officially change. Judge Layden, I'm not sure, have you seen this at all?
I have not, but it's more likely to be used in much larger cases.
Mm-hmm. So yeah. All right, now we're going to move on to the actual stipulation process. So the stipulation of facts is sort of the point of everything we've discussed leading up to this point. We're trying to do all of this informal and formal discovery to obtain facts and documents that the parties can then agree should be submitted to the court as part of the trial record. And the goal, again, is to get the parties to agree to any fact, any document that's not in dispute before the trial date. So we'll typically prepare a document called a Stipulation of Facts. It will list out all of the agreed facts, and it will attach all of the agreed documents as exhibits. Before COVID, it was normal for the Stipulation of Facts to be filed as late as the date of trial, often at the calendar call. And this was because in many cases, parties never, met in person until the calendar call, or petitioners may have not been fully engaged before that point. And this was challenging for both the parties and the court as far as being adequately prepared for trial, but sometimes there's just no way around it. Now the guidance has changed quite a bit. So the tax court now requires that the Stipulation of Facts be filed electronically no later than 14 days before the first day of the trial session. Just personally, I can speak to, in practice, this is very challenging. Obviously, when dealing with, unresponsive taxpayers or even unrepresented taxpayers that don't have access to the technology and things we've been talking about, that make it just very difficult to even have enough time, work so far in advance that you can exchange all the documents you need, have time to discuss them, negotiate, go back and forth, to eventually have a finalized, signed version of the Stipulation of Facts that can be electronically filed 2 weeks in advance. It can be very challenging in practice.
Rachel, Judge Layden, what we see many times is with unrepresented or self-represented taxpayers, they can't seem to get to the stipulation process. So oftentimes it's respondent, sometimes it's petitioner, will file proposed trial exhibits. We do have information about how you're supposed to number those. It's not always followed, and so we would urge you all to follow it. We came up with a protocol. Why we started 500 for petitioners and 1,000 for respondent was, some kind of best guess as to possibly how many documents might have to be filed. But if you're filing a proposed trial exhibit, if you're a petitioner, you're going to start with 500-P, 501-P. Respondent is going to start with 1,000-R. Here's one of the practical problems we're having at the court. Sometimes people file multiple proposed trial exhibits. And when we get to a trial session, the poor trial clerk has very little way of understanding which proposed trial exhibits should be called up. So it would be helpful if you're going to file multiple ones to label them first proposed trial exhibit, second proposed trial exhibit. Also with stipulations, because we're doing this electronically, you really either need to know how to bookmark and be able to call up each exhibit and the stipulation separately, or you need to have separate PDFs. It really holds up the trial if you have a 500-page or even a 100-page document, and we're trying to scroll through and find out which one is Exhibit 10J, for example. So that would be my advice to the audience.
Yeah, that's very helpful. The tax court. Mm-hmm.
Sorry, Rachel, the new numbering there on the slide. I just wanted to point the audience to that.
Yeah, that's great. There's on the tax court's website as well, I was just going to point out, under rules and guidance in the COVID-19 resources, there's a document that covers this in detail and talks about very specific things as far as file size and format. It should be in PDF, and if it's too long, it should be broken into multiple documents. I think one point is that the exhibit, each exhibit should have not only the exhibit number, but also should number each page within the exhibit, which I think should be standard practice, but it's very helpful, obviously, for everyone who has a document pulled up to know exactly what page, everyone should be on the same page. It makes it a lot easier. So.
And I can say from my practice, if a party has filed, if one of the parties has filed a pretrial memo, and we're going to get into that in a minute, and that has to be 21 days before the trial session. If the 14-day mark comes and there's been no stipulation of facts filed, I will call a conference call because I'll want to find out from the parties, are they really going to proceed to trial? And then I really try to impress upon them that they really need to have the stipulation of facts and exhibits filed at least a week before the trial session.
Definitely, and I know from our perspective, we really appreciate when the court gets involved and offers a conference call. I think it really encourages both parties to start working together and move forward as quickly as possible. There's a question at the bottom of the slide. What if a proposed trial exhibit becomes stipulated? Potential duplication issues. Judge Layden, do you have any thoughts on how to handle that?
Well, we're kind of working through this. If we get the trial exhibit, proposed trial exhibit, and then we get a stipulation, the court might issue an order making it clear that the proposed trial exhibit is duplicate and perhaps striking it. But it's one of the challenges that we're dealing with now when we have this sort of duplication. So I think where the court will head is we may be more proactive in issuing orders to make it a bit clearer before we start the trial session as to what has already been stipulated to and strike any duplication.
Thank you. That's very helpful. Just moving on real quick through the next slide. Sorry. Okay. So this just briefly covers a few other small points, but basically, again, the judge has ultimate discretion on how to handle documents that haven't been submitted in advance of trial. Personally, I have seen a trial happen where documents did come in just at the beginning of the trial session, and I think that between the judge and the trial clerk, it worked out very well as far as the chief counsel attorney was able to upload the document directly into the ZoomGov chat function to the clerk, and the clerk was then able to mark the exhibits as next in order so the court could consider them and rule on their admissibility, and it seemed to work pretty well. So that's just been my personal experience so far. All right, I'm going to turn it over.
This is a shout out to our trial, because the trial clerk has become quite facile in handling either on the fly. So I think the trial clerks are really able now to handle things that are either done by email or done by filing with the court on the fly. So we'd prefer that you not do that, but if it has to happen, I think the trial clerks are pretty well able to take a look and upload the exhibits.
Thank you. Here is where the rubber meets the road. The new standing pretrial orders under COVID-19 guidance. I'd encourage the audience to take a look at both of these links that are on this slide. But here's a summary of, the highlights of some things that you really need to be aware of. If you want to file a motion for summary judgment, 60 days now before the trial session. Motions for continuance, 31 days before the trial session. And then down at the bottom, the one I want to point out, 21 days for proposed stipulated decisions, pretrial memos, 21 days now. Motions to dismiss for lack of prosecution, or alternatively, a status report. And here, well, Judge, would you like to discuss this at all?
Well,
more on the stipulation of facts.
And it varies from regular cases and S cases. The regular cases order stipulation of facts, and the S cases say should. We don't have it as an ordered paragraph. But Again, because it is just so hard to turn on a dime, with being able to have the stipulation of facts in the documents, that it's really important that these deadlines be adhered to. As I said, I think some of the judges are also doing this. I'm pretty proactive. If I have a pretrial memo that suggests that there's going to be a proposed possible trial, or there's been a pretrial memo filed and I don't see a stipulation of facts, I get on right away. Just this week I had a session and I was on the phone on Monday. The trial session started the following Monday, with the parties and with petitioners saying you really need to get the stipulation of facts filed. And if not, we may have a problem. The benefit of remote trial sessions, however, is that if I have a session in, Aberdeen, South Dakota, and things don't go as planned and the stipulation of facts aren't filed, but the parties feel as though they can, I can set it on my next remote trial session, which may be arguably listed as another city, but I may have in 3 weeks from now. And so I will be able to have a trial session. So the flexibility that remote trial proceedings has provided the court, I think, is a benefit.
Agreed. We have issues with the unagreed to trial exhibits and unagreed to evidence in remote proceedings. Judge, could you also speak to this for just a moment?
Well, again, we talked a little bit about this, and that is when there's a proposed trial exhibit, and usually if it's a practitioner or if it's respondent's counsel, they're pretty good. They will be filed with the court. Service will be held to the other party, so the other party knows. Not so much on self-represented cases. Things may be coming in that aren't necessarily designated as proposed trial exhibits. Once, we're at trial, if someone, and I've had this happen, someone is on a phone, they're not on a computer, and they turn the phone down towards a piece of paper, and they say, I want this piece of paper put into the record. Well, we can't see the piece of paper very well, so then they put it up to a screen maybe, and you still can't see it very well. So, any of you who are helping unrepresented taxpayers, even if it's advising them and you are not entering a limited entry of appearance or general entry of appearance, assisting them in understanding the importance of getting any document that they can't agree with the other side to into the record ahead of time. I just can't tell you how important that is.
Thank you. And this is open to any of the speakers. We want to talk a minute about pretrial conference calls. And I guess Rachel and Jamie first, would you like to talk about when you and either side, either party, would proactively request a pretrial conference call with the judge?
I think it really just depends on the very specific issues that are going on. I think generally, like Judge Layden was saying, I think a lot of the judges are proactive. If you file a pretrial memo and it sort of indicates that you think a trial might be possible or that you're having specific issues, the court might initiate one. So I'd say generally the court, I think, has been doing the initiating, but if I'm having specific issues, I would also not hesitate to request a conference call with the judge.
Has your practice changed at all under COVID and doing everything remotely, work from home, etc.? Do you find the need to do this more or less?
I personally haven't. I think having a little bit more time built in has helped. Since the pretrial memos have to be filed 3 weeks in advance, I think it gives the judges a little more time to kind of go through their list of cases and figure out what needs to be done to get them moving. But that's just, I think, been my
and I think maybe so. My observation is from the other side, from the ordered by the court side, I am seeing that more frequently, at least, again, this is just anecdotal, under the remote proceeding guidance. Judge, would you agree, disagree, or say it's about the same in your experience
Where I
when the
have
court
seen,
orders?
yeah, where I have seen a real difference is when respondent files a motion to dismiss for lack of prosecution or failure to properly prosecute, which we ask to be done 21 days before the trial session. Petitioner may not respond. We may issue an order asking them to respond. They may not. Personally, when it comes in, again, if the petitioner is getting it by mail, it may be very unlikely that that person may get the actual copy of the motion to dismiss before the trial session. But I have been pleasantly surprised at the number of people who actually show up on a video conference. And that is heartwarming to me because it means that, you know, for the first time, they probably, one, they may be able to get representation, but two, they're actually able to connect with Respondents' Counsel. Because I can only imagine from Respondents' Counsel's side, it must be very frustrating to send letter after letter to someone or call someone and never have any contact.
I think anecdotally, I would agree that response rates are higher, you know, going to a calendar call as a pro bono clinician. I'm seeing more, and now virtual calendar call. I think a higher percentage rate of people who show up because they can do it remotely instead of having to, you know, drive, in my case, 70 miles to Los Angeles. So I would agree with that. Okay, we wanted to sort of wrap up with some observations of having watched trials now and listened in on YouTube when they're live, and some observations. Sensitivity to personally identifiable information. Judge, do you give an admonition or do you warn folks? And I could see this maybe with the pro se petitioners blurting out things that and not even thinking about it, that this is going live out to the interwebs.
I do. In my opening remarks, I say it, but as soon as someone starts, I cut them off and I ask the trial clerk to cut the feed. And this happens a lot if they have a new phone number or if they have a bank account that they want to read into the record. You know, in person, that person comes up to the trial clerk, gives the information, the trial clerk turns it to the judge. You know, no one else in the courtroom needs to hear it. But I do make a point in my opening remarks to mention that.
Have you seen many slip-ups?
No, I have not. People, you know, I think a lot of people are much more aware today about the bad things that can happen when you put your personal information out. So I've actually seen a lot more sensitivity to providing it in a public forum.
The next bullet point there I've discussed with several folks, and I'd like the judge's opinion. Do you have any concerns about who is really in the room, especially on, say, the petitioner side? And I think the bullet point there on the slide is, you know, maybe somebody feeding them answers. Have you, are you aware of that going on, or is that a concern?
I have not seen it a lot, but I have seen it, unfortunately. And how I might know is the person who's on computer might turn their head and look to a side and ask a question, which might prompt me to say, oh, is there anybody else in the room with you? Oh, yes, I have my friend who helped prepare a return. Oh, well, can that friend get on the video conference and introduce him or herself? I have also had it happen where the person advising the petitioner, who is not a practitioner, has been on by phone. You know, in the courtroom, it's a lot easier, right? We can see somebody sitting next to the petitioner, and we can have a discussion and say, well, if you're not admitted to practice, you really can't be advising the petitioner. It is much harder in Zoom. I have not seen it happen a lot, but it really is possible and much more easier to hide when you're on a virtual conference, especially if someone's on just by phone.
Right, and as to the last bullet point, in a trial where you want some person who is going to be testifying, an opposing party, to be out of the courtroom, that's very easy to do when you're in a courtroom. What about when this is being live streamed to YouTube and anyone could be listening, including that opposing party who's about to testify?
We usually end up giving an admonition to the party. We will either put them in the waiting room or a breakout room, and we tell them, you're on the honor system here. Please do not listen to the testimony on YouTube. But there's very little way that we can really police that.
Sure. That is it
for if somebody testifies later and there's information that was brought out in the first testimony, we'll have a sense.
Mm-hmm. That's it for our main presentation. We did want to reserve time for Q&A, and there are a lot of questions in the chat box that we'll try to get to before our time is up. But first, panelists, do you have any other observations or things that you want to get out that may have come to mind after we move past your slide?
The only suggestion I will make is if you are on a trial session and you get a notice, and of course, for those of you who don't know, when we set the notice of trial, that is a public document, but you get sent a separate non-public document with the zoom.gov sign-in information. Please don't share that unless, it's a colleague that's helping you with the case who's also in the case. But if you have any questions, do not hesitate to reach out to my Chambers Administrator and either ask for the question or ask for a conference call. Things are changing very quickly as we speak. We're trying to respond to new challenges and questions, and so we may not have faced the question that you have, but I would welcome people to contact us and ask for a conference call or ask the question of my Chambers Administrator.
Okay, questions from the audience. I'm first going to scroll through the chat box and let's see. Gina asked, can we ask Dawson and the powers that be to consider permitting us to upload the application fee waiver? Gina, I found out during this chat that you can, but it has to be done after the petition is filed. So I learned something new, and I will be experimenting with that too. Elizabeth asked, and I guess this goes back to when we were talking about depositions, when is a deposition appropriate? Anyone want to field that?
Sure. I mean, I think the tax court rules address it really specifically in different circumstances. So there's situations where the parties can consent. If you agree to the deposition, then it can be done. If they don't, then there's procedures that have to be followed to allow them to object, and then often the court will have to obviously get involved and weigh in. So I don't know if Judge Layden wants to discuss this at all. I don't know if, like she was saying, it's typically bigger cases.
Yeah, the only thing I'll say, I know it's not a preferred method.
Correct.
Sorry.
Right, and it's referred to as an extraordinary measure.
Exactly.
I mean, it might be applicable in today's unsettled world. If somebody, especially a party, is very sick, I hate to say this, but I have had a handful of instances where a petitioner has died prior to getting to the trial session. So that's the only thing I think has been changed in this environment.
Edward asks, how does a person produce exam books and other written materials in a paperless environment? Is that person obligated to reduce it to Dropbox or a flash drive? I think Rachel addressed that the respondent is still not allowed to use shared drives but the flash, Rachel, correct me if I'm wrong, the flash drive is appropriate, because I know that previously nothing could be, like back in the old disk drive days, you could not put in an outside disk in your computer. Can you put in someone's outside flash drive now?
We can. We disconnect from the network and then have to run the virus software and everything. But yes, we can. I think Edward was asking, right? Do you have to do that? And I think the answer is still no. I mean, we're still receiving mail. It just might take a lot longer. So to the extent that you want to, that if a party still only has it in a paper format and wants to provide it in that way, they still can. It just might take a lot longer for us to get back to you, but you don't have to provide it in an electronic format.
And Joseph asks, why doesn't the tax court require proof of service of subpoenas, as in the Federal Rules of Civil Procedure?
I don't know. That's a good question.
I was going to say I haven't thought about that. I don't know either, and that is a good question.
I mean, there is on the subpoena, I believe that there's something that has to be filled out by the person serving it, and then I don't know if that's really not filed with the court. So I don't know. It's a good question, and I don't know the answer to it.
I lost my place in line. Daniel, how do we label and integrate unagreed exhibits or impeachment exhibits numbering, given the new rule that they're filed 2 weeks in advance? I think we covered that back in used the 500 series and the 1000 series. I don't know if that answers your question, Daniel. I hope it was answered during the presentation. And Andrew's question, I think, might have partially been answered, but let me ask it to the panel. Andrew asked, does the court expect all stipulations of fact to be filed 14 days before the 14-day deadline? What if there are 2 stipulations of fact filed by then, but the parties are working on a 3rd stipulation, but just don't have it done by the deadline?
My recommendation is, first of all, you make sure you label them correctly. First stipulation of facts, second stipulation of facts, supplement to stipulation of facts, however you want to do it. And again, contact the chambers, ask for a conference call with the judge, and explain you're having problems, and give them some idea of when the 3rd stipulation of facts might be coming in. You might also, at that point, if you're doing 3 stipulation of facts, you might have some idea that you want a date and time certain for your trial. And that's another good thing to discuss.
Good point. Jonathan asks, can the tax court or attorney see who is viewing the trial? Is there a footprint? Well, from my experience, the only parties on ZoomGov are the parties, not the public. The public can see it via, or listen to it, not see it, via the YouTube live feed. But again, as the judge alluded to, we don't always know who is in the room on either end. Does anyone want to add anything else to that?
I don't think there's any way of keeping track on YouTube who is viewing it.
Brian asked, must all documents be in PDF to upload? I believe the answer to that is yes. The court does not accept JPEGs. Correct, Judge?
That's my understanding.
Fran asks, how about going straight to trial without depositions, and as depositions are just so expensive? Yes, I think that's the norm. And Andrew has another question. I have a remote trial coming up. I plan on being in the same room as my client, who will be a witness, and plan to inform the court that I'm in the same room as my client and we are on different computers. Is there anything else I should do in this situation to avoid any concerns that the court might have in this situation?
Well, this is Judge Layden. I don't think there's any concerns, because you're probably going to be, probably have different sort of tiles for each of you on Zoom. Again, if there's anything that you think is of concern, I would just let your judge know that that's what you're planning. I had a recent trial in which this happened, and I was more concerned that the parties were in close proximity and hadn't been vaccinated more than anything else, but that was their choice. But I did find it was difficult for the practitioner and the client to hear questions. And in that instance, I would say that they were maybe 8 feet apart on another computer. So that would be the only concern I would have.
Mhm. Yeah, and it seems to me that the fact that they are, like you said, on different tiles, that's a completely different situation where you have the unknown tax preparer not on camera, right, feeding answers. So here you kind of have each side disclosed right in front of you. John E. asks, what common mistakes have you seen by litigators in the virtual environment? I'll let the judge ask, but I would imagine there are many of the same mistakes that you see in the real courtroom. Is that right?
Yeah, no, I think the only ones, again, are not being facile enough with calling up documents, sharing your screen, if that's what you have to do. But I think you're right, Georgia, that, if you're a new litigator, you'll be making some mistakes that you would make probably in practice. But I don't think I've seen anything other than the handling of documents that might trip somebody up.
Yeah, or the accidental disclosure, right, after you give the admonition. And this one, I think, is for Rachel. If you have any inside knowledge or scoop, can you tell us when area counsel or when counsel will start returning to offices? Has there been any?
I have zero. I have zero scoop. We're allowed to access the office. I mean, at least in DC, we pretty much always have been. Our office is not closed. I go in every few weeks, so we just have a limited number of people who can be there at the same time. So it's not that we can't physically access the office, but they have not given us any guidance yet about when we're expected to actually be there full time or anything like that. So I have no details on that.
Okay.
Yeah.
Sorry,
George,
Richard.
I'm going to go back to Johnny's question, and that is where, of course, in practice, if you're sitting at the table next to someone, they can whisper in your ear, you can have a side conversation. You really can't have that in Zoom unless you have worked out a way to text one another and ask those questions. So that if you really need to talk with your client, you can ask the judge if it would be possible to take a recess and go to a breakout room. But that's probably another difference when we're doing things virtually.
I was just going to ask that, and you, as you were saying texting, the first thought that came to mind was, can you ask for a moment to be put in a breakout room? So that's good to know that you can. Finally, Chris, Chris doesn't so much have a question. It sounds like more of a complaint regarding the passwords on the zip files that are being sent when documents are being exchanged by email. Chris, I have had the same frustrations, and sometimes it has taken multiple attempts. I have a very good relationship with local area council, and they honestly don't know why this is happening. So for those not on who are just listening by phone, Chris asked that, or states that most of the time when you receive one of these encrypted documents from respondent, it doesn't open. And when you type in the password and double check it and triple check it and it still doesn't open, I've had the same thing happen and have asked them to resend it with a new password, and it opens fine. So I don't know, Rachel, if you have any comments or feedback on that, but there's my 2 cents.
Unfortunately, I don't. I haven't heard of that being an issue in my office, and I haven't had any issues with with the taxpayers or practitioners I've worked with. So I don't know if it's just who you're specifically working with that's having issues, but hopefully they can figure it out. Sorry.
Mm-hmm. Mm-hmm.
George, we had a question from Bruce. He's very frustrated. He sent in a petition in February. He said he got a record that the certified mail receipt that it's been delivered. And while we were on this, I did ask someone at the court. And here's the reply I got. Due to the transition to Dawson, plus several unexpected building closures over the intervening months. So if someone came down with COVID at the court, we closed. The petitions section is currently processing petitions received in early to mid-February. Please be patient. We're working through the backlog as quickly as possible. But if you want, you can send an inquiry, and he may have already done this, to dawson.support@ustaxcourt.gov.
That's great. And that seems about right as far as the timeline for things that we meaning my clinic, have sent in as well. It seems like I bet Bruce's petition is going to be processed any moment.
But, now we also accept petitions electronically filed. So I would encourage everyone out there to try that on. It's going to be a lot more seamless, and there's less likelihood of being the delay.
Great. We've got just about a minute left. Are there any other questions from the audience? Oh, Fran asks, when will we be able to search the opinions and memos over Dawson? And I think I have a follow-up question to that. Any first comments, Judge?
Okay.
Any idea of the time frame?
I don't. I know it is high on their priority, but for those of you who did not know, when we switched over from our old system to Dawson, it's like the IRS switching over to new computers. It was quite a monumental task. So the first things that were done were things that we could sort of keep the trains running. I know they're working on it. I don't have a time frame. I think it's very high on their priorities. If it helps you any, we too, the judges, we cannot even search the orders and opinions at this point. I would say that you probably just keep checking the website. As soon as they make these things available, they will announce it. So I'm sorry. I wish it was done also at the time we turned over, but I don't have any more update.
Right, and that's the what I had heard as well, that this is being rolled out in not so much patches, because patches implies fix, but being rolled out in sections. And the one that's frustrating me is not being able to see some of the documents I used to see, and for example, pulling up all of the area counsel who are of record, because usually the person listed last is top is usually a group manager who I don't want to bother or call because I know they don't have the admin file. So yeah, good question.
Okay, well with that, one more point. The other thing that has happened is, again, because of things that they need to program in, if I seal a petition, which I do sometimes when a petitioner unrepresented sends in stuff with terrible identifying information, I will seal the petition. Right now, if I seal any document, the entire case is sealed. And again, that is something that is being worked on, and when that is fixed, it would mean just that document would be sealed and people could see the other documents.
Yes, and I've run into that as well on some cases that I'm following. Okay, well, with that, we are at our time. Thank you, everyone, for listening and calling in, and thank you to my panelists. I really appreciate all your time on this, and glad to do it, even if it is a year late.
Thank you.
Thanks.
Thank you all.
Okay, great, thanks.
On behalf of the American Bar Association and the ABA section of taxation, thanks so much for participating in this program. To learn more about the sponsors, visit the ABA website, which is americanbar.org. Thanks so much, and please do click on the evaluation link as we value your feedback.